Good morning, everyone. Happy Monday. Welcome back to another edition of Beyond the Soundbite, where we talk about all things U.S. immigration. So, I am Carol Williams. I am with Williams Immigration. And if you know me and you've been following me for a while, you know I like to dive right in. So, the first thing I want to talk about this Monday morning is H-1B cap season. You knew it was coming. You absolutely knew it was coming. I've been talking about cap season for months now. So cap season, the initial piece of cap season is over. Yay. So what that means is that all cap cases were due June 30th. So that was yesterday. And what that means is if you were filing using paper, then they should have been filed by latest Friday, and then they will reach the Immigration Service today, which is fine, July 1. Whenever the due date is on a weekend or a federal holiday, they are due the next day. So if you're filing by paper, you should have already filed them, and it would reach the Immigration Service today on July 1, which is totally fine. If, however, you were filing using the online system, those were due yesterday, June 30th. So if you thought you could squeak in and file online today, you cannot do that. So just keep that in mind. So hopefully we're all done. We have all taken a deep breath. Now, what we don't know about this cap season is if it is truly completely over. We don't know if they're going to run a second lottery. So of course I will keep you up to date on that. Typically what they will do is they will see and do a huge count of everything they have. They will run all the stats, and they will determine if they truly have enough applications already in-house that when they are approved, they will meet the mandates of having 85,000 approved. And that is 65,000 towards the regular cap and 20,000 set aside for those who have master's degrees from U.S. institutions. So that's my cap update. So hopefully we're all breathing a little bit easier now that maybe the first part of cap season is over, or maybe just cap season is over in terms of filings. But I will keep you up to date certainly if there is another lottery selection. And you can keep yourselves up to date by checking your My USCIS accounts as well. So the second thing that I wanted to talk to you about this morning is last week we had a pretty major Supreme Court case happen that will most definitely impact immigration. So let's talk about it. The case we in the legal field called it Chevron. And let me explain to you why we care, what it does, and why I'm even talking about it. So the case really involves who can interpret federal regulations, and why do we care about that? We in the immigration world care about that because we deal with several federal agencies. We deal with USCIS, which is immigration, which is kind of short for immigration in our world. Customs and Border Protection, those are the folks that you see at the airports and ports of entry if you're at our land borders. Or you're taking a cruise in or out of the States. We also deal with the Department of Labor if you are filing an employment-based case. And we deal with Department of State. Department of State oversees the National Visa Center, as well as all of the consulates and embassies outside of the U.S. So in our immigration bubble, we deal with a lot of federal agencies. And oftentimes, if it is an employment-based immigration case, we deal with more than one of these federal agencies for one case. So who can interpret federal regulations? The way things were under Chevron, which is now old, Congress would make a law. That law was fairly vague, right? Congress is not going to sit around and think about all of the different things that can happen based on this law. They're going to issue a law. It is up to the federal agencies like USCIS, Customs and Border Protection, Department of Labor, and Department of State to then publish in writing regulations which tell us how they're going to implement the law that Congress has passed. Now, under Chevron, which again was just overturned and is now considered old, under Chevron, if the agency's rules and regulations were ambiguous or vague, the federal agencies themselves were the ones to clear up that ambiguity or the vagueness, not the courts. So we would have to go back to the individual agencies and say, hey, what did you actually mean by this? Usually those questions of, hey, what did you mean by this, came in the context of a case. When we had a live case with them, we were applying for a visa, maybe we got a request for further evidence, maybe we got a denial notice, maybe we got a notice of intent to deny, and we're like, well, what's happening here? We think this is vague. We think we made a great argument. The government says, no, you didn't. And here's where we are, right? So that's at the point where these questions of vagueness and ambiguity usually come in an immigration context. So again, under Chevron, we would go back to the federal agency and have them explain what they really meant when they wrote the law, not the courts. Well, the Supreme Court overturned Chevron. And now we have a new case, which is called Loper-Bright. That's the name of the case. Now, under this new case, Loper-Bright, and under this new rule, this new policy that we have out there from the Supreme Court, the courts can now clear up the ambiguity and the vagueness in an agency's rules and regulations. So again, why do we care about this? Because this new Supreme Court case overturning Chevron paves the way for more court involvement in immigration cases. It paves the way for the courts to come in and say, well, here's what we think immigration meant. Here's what we think Department of State meant. Here's what we think the Department of Labor meant. And here we are. They are not going to send us back to the federal agency to ask them again what they meant. Now, if we're in a court setting, the agency will be at the other table, right, in the courtroom, but the court now makes that decision. The court makes a decision instead of saying, hey, federal agency, go back and make a decision on this. The court is now going to say, well, it's in front of us, we're going to make a decision. So that means that the immigration landscape is going to change, and it could change tremendously. We could see different outcomes in different jurisdiction when the courts get involved. And so the courts don't get involved unless we involve them, unless we file suit and we request to go in front of a federal court. So in the immigration context, this could be huge, and it could really change the way that we look at immigration. It will change the way, potentially, depending on the number of court cases, that will change how we are looking at these rules and regulations. The other thing that we are looking at in terms of this new Supreme Court case is it's not just limited to immigration issues. This impacts all federal agencies. So think about anything that deals with any federal agency. So we're talking the Environmental Protection Agency when we're talking about environmental issues. We're talking about U.S. Department of Transportation, if we're talking about transportation issues, just to name a few. So it really opens this up to all federal agencies. So that's why I wanted to talk about this today. That's why I wanted to kind of give you a really 30,000 foot view of what this means. And it means ultimately within the immigration world, we may have this patchwork of court cases that we will now have to figure out and look at when we are strategizing cases and when we are chatting with you all, our clients. How do we move forward with this particular case? What has been what have been the recent court rulings? So this is pretty big. My legal colleagues and I have been talking about this all weekend. So wanted to bring that to your attention because we are going to see that change happen. Now, I don't know if it's going to be a slow change or if it's going to be a super fast change, but I do believe we're going to have more court involvement when it comes to immigration cases. So I will definitely keep you up to speed on that. And the last thing I wanted to talk about was an announcement that was made 2 weeks ago, maybe a week and some change ago, from DHS. And it is essentially throwing a lifeline to individuals that entered the US without documentation, are here without status, and are married to US citizens. It is throwing them a lifeline as a new way to get their green card without having to leave the US. So if someone has been present in the US and they entered without authorization, so they are undocumented, they entered the US, they have been living in the US for 10 years, at least 10 years. So they entered and took a residence here as of June 17th, 2014. They are legally married to a US citizen, and they don't pose a threat to national security, meaning they don't have a criminal record. They are eligible to apply for what we call parole in place. Once the parole in place is approved, then they are eligible to adjust their status and remain in the US while that adjustment of status is being processed, and then get their green card without having to go to the consulate. Currently, folks that meet these criteria have to leave the country and go to their home country consulate and finalize the processing. And the processing takes a long time. However, please know, one, this is completely discretionary. And two, because it is so new, because the announcement was literally just made, we do not have the process by which to apply. So it is still very new. We don't have the published regulations yet. We don't have the process. We don't know what form we're going to use. We don't know if the Immigration Service is going to create a new form or use an existing form and change that form a little bit. And we don't know what the government filing fee is going to be. So we are still waiting for all of those things. We're waiting for actual concrete specifics from the agencies. So once we get those, I will certainly let you know about them, but I wanted to remind you that this is out there and we are waiting. So that is what I have for you this Monday morning. If you have any questions about hiring someone that's not a U.S. citizen, if you have questions about, maybe you're here undocumented and you're married to a U.S. citizen, trying to figure out if you meet what they have laid out as the initial criteria, feel free to reach out to my office. We'll get you a consultation set up. We're happy to help. For right now, this is all I have for you this beautiful Monday morning. So have a great Monday morning. Have a wonderful rest of your week, and we will chat soon.